an exclusive. I haven't done this in a long time. I haven't done a live, but you got to hear this. Judge Glanville has got his hands caught in a cookie jar. And let me see if I can turn this around. I've got to be able to turn this around. Okay. How am I going to do this? Well, I'm live. Judge Glanville was wrong. He has violated Attorney Steele's due process. And because Attorney Steele will not tell him who this person is that he found out, had a conversation with the judge and the state and did not include the other attorneys, the defense team. So he filed a motion. He's filing a motion for mistrial. The judge tried to force his hand and make him tell who that person is, which is really wrong on all counts. And now they brought Ashley Merchant, who is the lawyer from the Trump case. Now you see how God is uncovering this whole entire debauchery. You got to see this, the rest of this. I'm trying to show y'all. I'm trying to turn this around. How do I turn it around?
Which is when you hold someone until they comply.
This is okay. This is okay. I'm just going to turn around, let y'all listen.
I'm going to take 5 minutes out. I'm going to think about it.
So now he wants to come back and think about it.
So we'll be in recess for about 5 minutes.
No, I'm not going to let y'all miss this. This is totally out of line. This judge, and here the state doesn't have his back. Here the state is shrinking down. Normally they're standing up with their hands on their hips and letting their backbone slip. And he has sat here and gone way too far and trying to charge him with contempt and lock him up, the attorney for Young Thug. So you guys have to see this. I had to stop the video that I was going to do just to give you this exclusive. Check this out. And I hope y'all can see it because I haven't been able to turn the screen around.
What does YRC stand for?
Hold on. Technically, the judge is charging him with contempt, trying to lock him up. He said, I just want to know who it is. I just want to know who it is. He's stalling the fact that he's wrong. He got busted. He got busted having conversation with a sworn witness.
I was on the wildest.
With a sworn witness. I was sitting up here watching, shout out to E-Band Films. I was sitting up here watching him, and a sworn witness was in the chambers with the judge and the state, and they're not supposed to be having these kind of meetings without the defense. And then I don't even believe the witness's attorney was available, but just Ashley Merchant is on it now.
And I think the judge went ahead and did some other things that caused that.
Homie with the pony junior.
To be that issue presented. So I'm going to take a look at the other case. That was in rehab. That was 215 Georgia 372.
Yes.
The other case is 7.
And there's several others when you're ready.
Look, Miss Love now. She's not even involved in it. She ain't standing up saying nothing now. This is outright, and now he wish he'd never done it. I hope y'all can see this. I'm standing up trying to give y'all this.
That do the magic, y'all.
This exclusive.
Penn and Teller. That's their name. Yo, look like one of them niggas.
Shout out to E-Band Films. Was watching this and catching the tail end of this.
Oh, I'm tripping.
Ha! I know he wish he had none.
I don't even hardly know them niggas.
I know he wish he had none. And she's asking for Attorney Steele to have a bond. She's asking for a bond. He wants to find a reason not to give him
a real quick. He unprepared.
Yeah, he is.
Bit off too much.
Yes, he has. He's bit off too much, more than he can chew.
He bit off more than he can chew.
I just said that.
Yeah. You on the internet Googling shit? AI like, yo, I can't help you. Glanville, you in this thing by yourself. You know it's messed up when the AI won't help you. AI holler, nah, cuz. Nah, cuz.
This is a shame. And Ashley Merchant is his attorney in this case. And what she's saying is that the judge has to recuse himself. It has to be a whole separate hearing on this contempt case. And he's a witness, so he can't even be a hearing over it. It has to be heard by another judge. And he has to succumb himself underneath another judge to hear this case that he's put his hand in the cookie jar on.
And then they deal with it. That's why she like somebody that stole something from you, but they still there, and you looking for it.
The contempt is directed. Trial court has the power after before you contempt authority, opportunity to speak in his own behalf, announce punishment and ask for the notice of hearing. I already did that, Mr. Steele. He's already told me. I already gave him the opportunity to do that. So we had that conversation this morning already.
He's made this a mess, y'all.
And Judge, so there's a couple different issues. First, the question is whether or not you need to have that hearing now. I know you're saying that you had the hearing earlier, but regardless, he was entitled to.
He didn't have a hearing. He didn't have an attorney.
So the question is initially whether or not you even need to hear this now. And some of the cases I've cited, along with some others, say that a summary proceeding is not necessary in a case like this. And the best evidence of that is the trial has continued. It has not stopped this trial. So for you to hold a summary hearing of direct contempt
and then keep going with the trial,
able to state how this interferes with your ability to administer justice in this case.
I can tell you because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people, and as to how that information was disclosed, that's a real problem. That's why it's of such an issue for the court at this point in time.
Judge, and Mr. Steele has.
Look at Attorney Love. She's just rubbing her head, just looking. She acting like she ain't paying attention because she don't want no parts of this, because they've been doing stuff underhanded and dirty the whole time. This actually is ridiculous where it's gone to in this Young Thug trial. I just had a video that I was preparing to release, and all of this happened on this day towards the end of the hearing. It's Ashley Merchant comes up and says, I'm representing Brian Steele, and we've got about 25 other lawyers that we want to be able to get in this courtroom. They're not playing. They got the guns drawn because Brian Steele has forever and a day filed motions back and forward, and have them denied. Motion for mistrial. Well, now the judge has put himself in a position where he cannot wiggle his way out of this one, y'all. Pay attention. Watch this.
First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Dang. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith.
Say it,
he
girl.
believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you aren't part of that by nature. Okay. You have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
But you got the information. Because here's the thing: you got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I say that one of the things is he is.
Why? Just because he will not disclose to you the person or how he got the information. So you want to know who it is. Why do you want to know who it is? Because you can put a hit out on them. So you can do whatever. So you can plan your smooth exit or plan your strategy on how to cover up how wrong you were for filing him, for bringing contempt on this great lawyer that's been doing a great case for his client, and have been sitting back while the state has been doing all kind of trickery all through the case. And here you want to throw contempt on him?
Which I don't believe he did at all. I don't believe that for a minute. But I do believe that somebody did tell him what was the sum and substance
what you believe
of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So at this point in time, is there anything else you want to tell me?
She's asking for a bond, crazy.
So first of all, we would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to.
Damn.
He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge.
That's right. Now what? Ha.
And he has the right to subpoena witnesses.
She took a sip of water.
I like the way she's taking that water.
Show cause hearing. Notice of the alleged violation, whatever rule it is that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't. For it to be ex parte, you have to be a witness. It can't be both ways.
Somebody has stumped the judge, finally has cut off his water, finally has got him to be quiet. They have stumped the judge because the judge is wrong. Bam! If I was a judge, I hit the gavel. Bam! You better give him a bond. You better watch what you say from this point forward, Judge Glanville, because you're wrong. You're wrong on all counts. You should never have done that to this man of God, to this attorney Steele. Now you know what you're dealing with. You're not dealing with a normal case. Somebody was trying to tell you, Attorney Steele was trying to tell you, this is not a normal case. You should have known this is a case that God is allowing to happen, and he's allowing it to happen so that all the travesties of injustice that are going on in the Fulton County courthouses is going to be debunked. Go ahead, Ms. Merchant.
I'll let the appellate court decide that. So, anything else?
No, we'll file a notice of appeal.
Okay.
And we need to have the order reduced in writing.
I'm going to do that right now. I will state for the record at this point in time that Mr. Steele has in fact, or has filed, and I will note this as part for the record in this case.
And he's being so stubborn. He doesn't even know he's digging a ditch that's deeper than he even understands. He can't even fathom. He is digging a ditch for himself. He does not even understand. He said he's going to let the court decide. They're going to have to go through an appeal process because he's so stubborn. He's stubborn. He was too stubborn to listen to Brian Steele. Now, Ashley Merchant is up there telling him, look, Judge, you have to recuse yourself. You can't even be a part of this because you're a witness. And he's still stubborn. He's saying, I'm going to let a court of appeals decide that.
He's filed a motion to set aside the contempt. He's filed a motion for a superseded bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself of the contempt just by telling me who it was, and he can do that this evening. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant the bond. at this point, grant him a bond on that issue.
You don't get a superseded bond on a.
See how stubborn he's been?
You can grant him a bond.
No, you don't get one on that one.
The civil is the one that you can hold him until he complies with the order.
And I'm sorry, I think in,
Just a case law on that.
He's so determined to have his way. This is, I don't know who he's married to, but this man is so determined to have his way. I wonder if he's a Virgo. I'm sorry, Virgos. He is so low down.
the superseded bond requirement does not apply in the contempt in the presence of the court during the progress of a proceeding OCGA 5-6-13 Bravo. So you don't get a supersedious on that, on a criminal contempt, respectfully.
So Judge, just to clarify, it's your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
The judge, the reason I'm asking is because the N. Ray Hughes case, which is a 2009 Court of Appeals case, 268, Georgia Appeal 66, lays out the distinction, as does the Ramirez case.
There's a case that in fact I'll do you one better, sir. In fact, there is a recent pronouncement out of our appellate courts.
Which is, I think I'm addressing a slightly different point of law.
It is. Maybe two cases. One is it's Untema. It's UNTEMA versus Smith, and that's 371 Georgia Appeals 19. Which was decided March the 12th of this year. It covers the differences between the types of contempt. And then there's another case that I'd put your attention to, and that is Henry Syverson. It's SYBERTSON, and that is 368 Georgia Appeals, Georgia App, I should say, 865. And that was decided July 31st of last year.
And Judge, I'd just like to point two things out. The statute that you were citing about the supersedious, it only says it's not mandatory. You still have discretion to grant him a supersedious bond. The other,
I'm not going to grant a supersedious.
and so you definitely have the discretion to grant him a supersedious bond. The other issue is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies.
No,
criminal is where you get to impose a sentence, maximum 20 days and $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
Well, his contempt is as long as he when he tells me
You cannot make up a contempt rule, Judge.
I didn't ask.
It's either $1,000 fine or 20 days.
He purges himself of the contempt.
Then that's civil, Judge.
That's civil contempt.
That's civil.
And that's respectfully, I would point you to In Re Hughes, which stands for the same point of law. Civil contempt impose punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge, which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license. And so he's in a very, very difficult position where if we were able
It's a very precarious
have a
position.
full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that takes away the whole point of criminal contempt, and that is you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal.
So this judge's problem is this judge thinks he's his daddy. This judge thinks he is Attorney Steele's daddy. He's been talking down to him like he's his daddy. He doesn't treat the state the same, but he talks to Brian Steele and Attorney Shard like he's their daddy. So he would get off of that daddy suit, take that daddy's hat off, and do what's right, and stop getting his feelings in the way, and realize that this attorney has the right to hold that privileged information to himself and not do this, then I would have respect for him. But no, he's stubborn, and he's stubborn for a reason, because God is going to have the final say in Fulton County. All of this is going to be uncovered, and I doubt very seriously if that stubbornness will be taken off of him. It reminds me of Pharaoh when he was stubborn and did not want to let God's people go, and Moses go. And guess what? Who had the last say? God did.
Immoral, unethical. I just asked him to tell me. I know what the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him.
We don't want to hear you.
Who?
He doesn't want to tell you who, and he's not going to tell you. You're not going to make him tell you.
To us that he does not believe he can answer that question without also violating the privilege.
Okay.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about it just a second, okay? I'm going to take 5 minutes out. I'm going to think about it.
Thank you.
So, okay, all right. So we'll be in recess about 5 minutes.
Yeah, I can't believe this. I can't believe this judge. I'm going to try to speed it up for y'all because I've been stopping it, so he's probably come back. I can't believe this. This is just hypocrisy. This is ludicrous. This is horrible. It's horrible. It's horrible to treat somebody like this. His courtroom has been a farce the whole time. This is, even if it went to appeal, they would lose. And he keeps giving the state chance after chance after chance, but he wants to treat the defense like they're his kids and like he's their daddy. But anyway, let's just wait and see what he comes up with. This is graceful exposure. I am going to sign off on this one and let you guys just see the end of it in one moment, in 1 second. Sorry about that.